In conclusion, even if you knew the answer a year ago, it could have changed. Immigration law is constantly evolving. On top of that, smallest changes in facts can change the results drastically. One of the biggest problems, two of the biggest problems in immigration law are governance by edict. Send out a memorandum, the law changes overnight. And we've seen this happen time and time again. And sometimes it's very frustrating, very annoying, and very unsettling. How do you explain to your clients that the government has the authority to change rules midstream? Just when you thought you knew what the law was, they go and change it on you. So immigration law, immigration governance changes almost every day. On top of that, smallest changes in facts can change the results. So two problems with immigration law: the flux because of unfixed government opinions, and two, there are so many gray areas where rules, regulations, policy are just not applicable. And only if you are living in the trenches you will get exposed to those areas of the law. Please go to a competent immigration practitioner. If you're not convinced the person is competent, get a written opinion or at least take contemporaneous notes, because as you know, under federal rules, you could adduce that as evidence. Now, this may not be a perfect defense, as I mentioned earlier, but at least it gives you the option or a defense against allegations by the government of willfulness. In one of those cases that I had mentioned, I think Cersei, you'll see that the judge mentioned, the ALJ said, did they consult counsel? So when the investigation started against the company, did they go outside and get themselves a lawyer who could advise them? So the fact that you sought legal advice would go a long ways towards helping you. But here is a problem. I am reminded of a case where 3 lawyers, myself included, and I had practiced by that time a couple of decades in immigration law, we all made an error of the law. Why? Because that particular case involved a Canadian citizen. Many of the immigration rules that apply in a certain way to the rest of the world apply differently to Canadian citizens. The general counsel of the corporation that we were dealing with, their in-house immigration expert, lawyer, and I, all 3 of us made the same error. Well, I would like to say that I refined their errors and perhaps narrowed the number of errors, but yet at the end of it, we were all guilty of the same error. Because we had made the same error, immediately we caught the individual employee in. Luckily, this company was a multinational. We could move him around. It wasn't the end of the world. But nevertheless, we all made the same error. Again, fortunately, we were able to get that error reversed. I don't think we filed a lawsuit. I think what happened was when we argued the case with the government, it was a gray area of the law. They did rule in our favor. For those who know already what's involved here, basically there was no I-94 issued when he entered USA. So our argument was that unlawful presence was not applicable, so you could not bar him from entering USA for 3 years. So unlawful presence could not be triggered because there was no I-94 issued. So eventually we did win that case, but it was very, very scary for a long time. So be mindful of this flux and this gray areas of the law, and I wish you the very best of luck. Thank you for being here.